Very good afternoon, judges, participants, and all the audience. This courtroom is now in session, and we'll begin now.
Honorable judges and participants, warm greetings to all of you present here. I am Aditya Raj, the court master for this moot court hall, along with Shashwat, who will serve as a timekeeper. Before we start the proceedings, I will expeditiously read aloud for your consideration a few important rules and regulations of this first CCI-MNLUCS National Antitrust Moot Court Competition 2025 for the reference of all the judges and participants. Team Code 25 shall represent the petitioner in the instant case. Team Code 37 shall represent the respondent in the instant case. Each team would be given 60 minutes to present their oral arguments, subject to a maximum of 30 minutes per speaker. Judges, at their discretion, may extend oral argument time up to a maximum of 10 minutes per team. Rebuttal of a maximum 10 minutes will be allowed only to the teams, and the same is included in the total time allotted to the team for arguments. Both the teams have already informed the timekeeper of the time required by them for their oral arguments and rebuttal. Please note that the timekeeper shall, after every 10, 5, and 2 minutes, display a time placard for the convenience and reference of all the participants and the judges. Please note that the time limit shall be seriously followed, and all the teams are requested to comply by the same. Please note that the use of compendium is allowed subject to the discretion of the judges. After the completion of the round, the teams shall leave the courtroom immediately for deliberation by the judges. Any request for remarks or suggestion must be sought outside the courtroom and shall be at the discretion of the judges concerned. Now, the team bearing Code 25 shall present arguments for the petitioner's side for the total period of 60 minutes, with 10 minutes reserved for rebuttals. The first speaker of TC 25 will speak for total 26 minutes. I now request Team Code 25 to start with their arguments.
Counsel seeks permission to address the bench collectively as your lordships. Much obliged, your lordships. Your lordships, if you may permit, the counsel would like to provide the compendiums. Court officer. Much obliged, your lordship. May I proceed, your lordships? Indeed.
Maybe then you speak. Mine is working now. So yeah, it's working fine now.
Hello? Check.
May I proceed, your lordships?
Yeah, please proceed. Yes, please proceed.
Much obliged, your lordships. Your lordships, counsel appears representing the petitioners in the case of Data Now and ConnectVerse versus the Fair Competition Authority of Bharat. The present counsel will be dealing with issues 1, 2, and 3, and my co-counsel will be dealing with issues 4, 5, 6, and 7. Your lordships, if you may permit, counsel seeks permission to move to the facts of the case. Yes, please. Much obliged, your lordships. Much obliged, your lordships. Your lordships, in 2015, ConnectVerse acquired Data Now. In 2021, Data Now introduced a data sharing update aimed at enhancing privacy and offering clarity regarding business communications. Pending constitutional challenges of the 2021 update, the FCAB, acting with only 2 members, one less than the statutory quorum, have passed an order under 26(1) for investigation to the DG. Aggrieved by the same, the petitioners have approached the court today. Your lordships, if you may permit, counsel seeks permission to proceed to issue 1. Much obliged, Your Lordships. Your Lordships, under issue 1, whether or not whether the investigation order issued by the FCAB is invalid due to an absence of statutory quorum, Council will be proving the same upon 2 sub-prongs, Your Lordships. Firstly, Your Lordships, that the absence of a statutory quorum vitiates the jurisdiction of the FCAB. And secondly, Your Lordships, that the doctrine of necessity cannot override explicit statutory mandates. Your Lordships, if I may proceed to read out section 22(3) of the Competition Act, the proviso. It states, provided...
Just give us a second, please.
Indeed, Your Lordships.
Yes, please.
Your Lordships, it specifically mentions, provided that the quorum for such meeting shall be 3 members. Your Lordships, such meeting term has not been given under section 26(1). However, it must be contextualized with regards to the regulations passed by the CCI. If I may give the meeting for transaction and the general regulations of 2024 to the bench. Your Lordships, under 17(3) of the general regulations of 2024, it specifically mentions the Commission shall, as far as possible, hold its first ordinary meeting to consider whether prima facie case exists. And under the meeting for transactions of business, it has been specifically stated that ordinary meetings under 3A, that ordinary meetings related to a statutory inquiry or investigation or other proceeding to be conducted by the Commission. With regards to the same, Your Lordship, this contextualizes the meaning of the word meeting to mean that when a prima facie order has to be formed by the FCAB, it must be given in terms of a meeting. And the proviso for section 22 clearly states that there is a mandatory quorum with regards to the same, Your Lordships. Your Lordships, moving to the case, the use of the word shall under the proviso itself. Your Lordship, it has been held in multiple cases such as Lakshmi Narayan versus Union of India, given in flag 8, given under flag 8, paragraph number 68 of the compendium, where it states that the use of the word shall is mandatory in nature and not directory in nature, Your Lordships. Furthermore, Your Lordships,
tell us the paragraph number, please.
Paragraph number 68, Your Lordships.
Go back again, please.
Page number 11. Page number 11, the highlighted portion, Your Lordships. If the provision is couched in prohibitive or negative language, it can rarely be directory. The use of preemptory language in a negative form is per se indicated of the intent that the provision is to be mandatory. Furthermore, Your Lordships, section 17, which acts as a savings clause for vacancies, Your Lordship, it was present in the previous MRTP Act. However, Your Lordships, this quorum requirement is a new addition in the Fair Competition Act. This clearly shows the legislative intent to require a statutory quorum for a plurality of views with regards to the fairness in forming a prima facie opinion itself, Your Lordships. Furthermore, Your Lordships, in the case of Alliance Digital India Foundation versus CCI, Your Lordships, flag 7, paragraph number 77 and 79. Flag number 9, apologies, Your Lordships, flag number 9.
Flag
9, page number 26 and 27. When it has clearly been stated, the provisions of section 22 appear to be purely in respect of administrative action to be undertaken by the Commission and have no nexus with the adjudicatory process, Your Lordships. Then in 79, it has been stated clearly that the court has already concluded that the word quorum employed in the proviso to subsection 3 to section 22 has no nexus with adjudicatory process of the CCI and is limited only to its administrative actions. Your Lordships, this clearly states that section 22, the proviso to section 22(3) mandates a statutory quorum for meetings, administrative actions that comes under section 26(1). Your Lordships, furthermore, when such a mandatory statutory quorum has been stated in the legislation itself, it does not become a mere procedural irregularity. It strikes at the jurisdiction itself. It is a jurisdictional precondition as held in the case of Janta Land Promoters versus Union of India. Your Lordships, if you may permit, I will move on with the second prong of my issue. Your Lordships, secondly, Your Lordships, that the doctrine of necessity cannot override statutory safeguards, Your Lordships. Your Lordships, the Council would like to submit that the doctrine of necessity is a narrow exception to bias, Your Lordships. It is not an overriding. Doctrine.
A narrow exception to what?
Bias.
Bias.
Bias. Your Lordships, it is a narrow exception to bias, and it does not have such wide or overriding effect that it could override even a mandatory statutory quorum. Your Lordships, in the case of J. Mahopatra versus State of Orissa, flag number 2, Your Lordships, para number 12. Flag number 2, para number 12, page number 5. It has been specifically stated, Your Lordship, that there is an exception to the above rule that no man shall be a judge in his own cause, namely the doctrine of necessity. An adjudicator who is subject to disqualification on the ground of bias or interest in a matter which he has to decide may be required to adjudicate if there is no other person who is competent or authorized to adjudicate, or, Your Lordships, if a quorum cannot be formed without him, or if no other competent tribunal can be constituted. Lordships, this case was also looked at in the Alliance Digital Foundation case, and it was accepted that in this case, it has been clearly stated that the doctrine of necessity can only apply when a quorum itself has been constituted validly, only then, post which, if any bias has been found within any of the members, only then can the doctrine of necessity be invoked to then save the proceedings, Your Lordships.
Counsel, in this situation, what's the reason? Is there like a shortage of...
Yeah, indeed, Your Lordships, it has been specifically mentioned in para number 10 of the proposition itself, Your Lordship. If I may read out.
Can you take us to that para?
Indeed, Your Lordships. It has been stated that, if I may read out the same, it may be pointed out that at the time of passing the order under Section 26(1) of the Fair Competition Act 2003, the FCAB was functioning with an acting chairperson and a single member, thereby falling short of the statutorily prescribed quorum of 3 members. However, the validity of the said action was sought to be justified by the provision contained in Section 15, and the doctrine of necessity was invoked to justify the continuity by the FCAB.
And then can you read sections 15 for us and explain how is that not relevant for us?
Indeed, Your Lordship. Your Lordship, Section 15 talks about vacancy, etc., not to invalidate the proceedings of the Commission. Your Lordships, it states no act or proceeding of the Commission shall be invalid merely by reason of A, B, and C. C specifically talking about any irregularity in the procedure of the Commission not affecting the merits of the case.
Or A, any vacancy as well.
Or A, any vacancy also, Your
So
Lordship.
isn't 15 an exception already to 22 like you highlighted, or it's not?
Your Lordships, the interpretation that the Council would like to put forth, the harmonious interpretation that the Council would like to put forth, is that Section 15, as held also in the Alliance Digital case, that Section 15 provides for an exception only to the judicial functions of the FCAB, Your Lordships, and the administrative actions are mandated under the proviso of Section 22(3), Your Lordships. Furthermore, Your Lordships, in that case as well, it would...
Section 23?
22, Your Lordships.
Counsel,
Apologies.
Counsel, are you trying to say that that exception only applies to judicial functions and not to administrative functions? You're saying that like they can kind of proceed with judicial functions without quorum, but administrative they can't.
Indeed, Your Lordship.
That's sometimes a little surprising because judicially would be a much more stronger thing. I mean, so they have an exception to a much stronger thing, but rather than administrative. I would say other of course might be true.
Indeed,
Your
Lordships, in the Alliance Digital Foundation case, it was exactly this question that had come forth before the court with regards to the judicial actions, and it was held that, and they sought to save the same using Section 15, and obviously the respondent said that Section 22 would apply, but the court then specifically clarified that Section 15 saves only judicial functions, and Section 22 is a mandate with regards to the administrative actions.
Counsel, can you help us understand as to how the Commission cannot look at administrative orders, but can pass a final order, and give us something as a High Court that binds us, so that we are able to take that view if we can?
Your Lords,
Show us something that binds us as a higher court, establishing that a lower court couldn't have passed an administrative order, but could potentially pass a judicial order.
in the sense of the Alliance Digital
or any
Foundation
other
case,
judgment
Your
of any
Lordship.
other higher court. higher to us so that we have some value to look at.
So council, there has to be administrative decisions that will have to be taken by the authority,
Indeed, Your
commission.
Lordships. Indeed.
Only then it will lead to a judicial proceedings.
Indeed, Your Lordship.
If, according to you, the case that you're quoting
Indeed.
protects judicial function, but that
Indeed.
does not apply to administrative function, without taking certain administrative steps, they cannot discharge their judicial functions.
Indeed, Your Lordship.
So what my brother judge is asking is if you can just explain to us or present any case that will bind us so we can rely and we can kind of rule in your favor.
Your Lordships, the Alliance Digital case, although it has specifically talked about it, with regards to any other case, Your Lordships,
Can you
even
take us to the relevant paragraphs of the case so that my senior judge is able to appreciate?
Indeed, Your Lordships, of the Alliance Digital Foundation case, Your Lordship. Your Lordship, it is under paragraph 77 and 79 and flag number 9, Your Lordship. So it is under page number 26 and 27.
We got the page here. Now you
Indeed, Your
can tell.
Lordship.
Yeah.
Indeed. So, in Your Lordships, in this case, it was a single bench of the High Court of Delhi. However, it is one of the only cases that truly discuss the lack of a quorum and how Section 22 would be applicable in the same. So, and hence, due to the fact of the similarity with regards to the facts and the fact that specifically Section 26(1) or 22 and 15 were being harmoniously interpreted by the court, the council would like to put forth that case with regards
Council,
to
that's
this.
appreciated. This is a single judge of a
Indeed.
similar court.
Indeed, Your
Would you have something for the bench that binds us so that we are able to, rule in your favor if we were to?
Your Lordships, although not specifically
It may
this
not
case,
be a competition
in not,
commission issue, it may be any other regulatory body issue, but something that binds us so that we don't have to look at a single judge bench when this is clearly a larger bench than that one.
Indeed, Your Lordship, just one moment. I will. Your Lordships, at the present moment, with regards to the quorum specifically, there are two cases, MNLU-Labs and the Alliance of Digital Foundation, both passed by the Delhi High Court, talking about, although in the MNLU-Labs case, they were talking about how doctrine of necessity is applied, and it is only applied with regards to there was a lack of quorum in the same. The IPAB bench, the copyright bench of the IPAB was held to have no technical member. So what the court did was that they took the technical member from the plants varieties bench and held that now doctrine of necessity applies, and you both, and because you both form the quorum, you guys can now then proceed with the proceedings. But they did not hold that the judge, the single bench, could then proceed with the proceedings without looking at, due to doctrine of necessity. They specifically held that first the quorum must be maintained, only then can doctrine of necessity be applied to then create circumstances in which the two can the two members could have looked at the same, Your Lordships.
And Council, we are also saying that in that matter, there was
It was a single judge, indeed, Your Lordships.
There was a section similar to 15 of the Competition Act, where you still could have quorum even if there was a vacancy if 15A was there or a similar provision was not there.
Your Lordship, a similar provision in Your Lordship, a similar savings provision itself was not there, Your Lordships. However, in the case of access, if I may just request
Please,
the
yeah.
proposition, my memo, our memo. Your Lordships, just one moment, Your Lordships. Your Lordships, in the case of, yeah. Your Lordships, in the case of the Alliance Access Stock Exchange Limited, although not in the compendium, they specifically had a section, exactly section 15R of the SEBI Act, which stated that these vacancies would be saved. However, there also it was mentioned that the quorum would be saved with regards to this.
Of the statute or of what you're showing us?
Your Lordships, presently the council does not have the same. Apologies for the same, Your Lordships. Your Lordships, if I may proceed with my arguments, much obliged, Your Lordships. Furthermore, Your Lordships, if you may proceed, if you may permit, may I proceed with issue 2?
Yeah, please do that.
Due to the fact that, as I've already stated, that the statutory quorum mandate of 2022 would mandate the fact that FCAB have 3 members before passing any investigative order, and secondly, that doctrine of necessity cannot be applicable due to the fact that the quorum itself was not established. Your Lordships, under issue 2, whether the FCAB is legally obligated to issue a prior notice or afford an opportunity of hearing, the Council would like to present it under 2 prongs. Firstly, that principles of natural justice do apply to administrative actions, and secondly, Your Lordships, that the civil consequences that the petitioners would face require at least a minimum requirement of a notice, Your Lordships. Firstly, Your Lordships, in the case of A.K. Krapak versus Union of India, flag number 3.
Counsel, we'll have to stop you here. I mean, what civil consequences are you talking about in an investigative process? It's a mere fact-finding exercise.
Indeed, Your Lordships. However, under the specific Directorate General, the sort of inquiry that they conduct and even the order that they pass, it causes reputational harm. It causes the petitioners to reveal sensitive documents that they would not have otherwise been forced to reveal, and it also caused not just consumer, like in the sense that the reputational harm that is caused by them is on all fronts. The consumers as well switch the apps due to the fact that the FCAB has given such an order, and even the investor.
Was this order on public domain?
Your Lordships, the order with the reasonings do not go. However, the DG conducting an investigation would become public, Your Lordship. Just the fact that there has been an order to the DG.
I hope you're sure of that, but because if an order is not there in the website or public domain, I don't know how that reputational harm will come in.
Indeed, Your Lordships.
And Counsel, could you explain as to why, when the Commission's DG office is causing an investigation, there's going to be public disclosure and the harm around it?
Your Lordships, with regards to the DG investigation, it won't be public. That will be confidential, Your Lordships. But the fact that the FCAB has ordered an inquiry into and has formed a prima facie opinion
But
that
Counsel, you yourself suggest that the order of the Commission is not in the public domain. It's not on the website. So the fact is that it's a private order issued to my own or the Commission's own DG, and the DG is causing an investigation. How is that leading to disclosure and therefore harm on somebody's reputation?
Your Lordships, when the company itself finds out, they are bound to disclose to their investors that there is a certain inquiry that is happening in front of them.
Is this a listed company in India?
Your Lordship?
Is this a listed company in India? Are the
Or
obligations
overseas, or holding companies overseas listed? Because otherwise the disclosure need not be there to the investors, and if it's not on the website, we don't see the reason for reputational harm anyway.
And also, Counsel, you will have to establish what is the standard of civil consequence that requires hearing, because that's something that you will have to take us through. Because just because you say that there's going to be reputational harm and it's going to affect the investors, that is not a sufficient standard which warrants a hearing at this stage, because it's purely administrative, it's fact-finding.
Your Lordships, although the Commission creating a prima facie opinion is fact-finding in nature, however, the entire basis for creating an order or issuing a notice to the DG that the DG must investigate is on the basis that they form an opinion that the petitioners have violated the provisions of the Competition Act. Furthermore, Your Lordships, the petitioners are also contending that such a prima facie opinion could not have been formed in the first place, as will be elaborated upon by my co-counsel. And in the present case, when such a prima facie opinion is not even justified, and the fact that such an order would be causing harm to them because they have to disclose these sensitive documents when the DG requires such sensitive documents, or when they conduct an investigation, the petitioners are bound by the same. They must comply with the same, Your Lordships. And when such a prima facie opinion is not justified itself, then the civil consequences are also not justified, Your Lordship.
So that's exactly what we're asking. What are the civil consequences you're talking about, and where are you getting this definition of civil consequences? If you can just take us through.
Your Lordships, in the WhatsApp case itself, Your Lordships, in the contentions of WhatsApp, they specifically stated, Your Lordships, that due to the fact that there has been an order for an investigation, they specifically mentioned that due to the same, their customers were then shifting to other platforms and other applications, causing harm to them, just due to the fact of this this inquiry that was being conducted by the DG, Your Lordships. And these sorts of costs that come about not just as like compliance costs, but also the reputational harm with regards to the consumers, and the fact that the consumers or the customers of the data now's application can potentially switch due to the fact that there is no due to the fact that multi-homing is in place. Due to the same, the data now does have certain civil consequences. And furthermore, Your Lordship, in the case of SL Kapoor versus Jagmohan, flag number 12, para number 24, flag number 12, Your Lordships. Page number 39.
By the way, keep in mind that you have another third point to argue.
Indeed, Your Lordship. Just this one point, and then I'll move on to issue 3. Indeed, Your Lordships. In our view, the principles of natural justice know of no exclusionary rule dependent upon whether or not it would have made a difference if natural justice had been observed. The non-observance of natural justice itself is prejudice to any man, and proof of prejudice, independently of proof of denial of natural justice, is unnecessary. It will comes from a person who has denied justice, that the person who has been denied justice is not prejudiced. Your Lordship, specifically stating the fact that the mere non-observance of principles of natural justice itself creates prejudice in the same. And further, Your Lordships, the burden of proof is not upon the petitioners to prove why principles of natural justice has not been followed. However, it is on the respondents to prove why principles of natural justice have not been followed. Your Lordships, with regards to the same, counsel seeks permission to proceed with issue 3. Much obliged, Your Lordships. Your Lordships, with regards to issue 3, whether or not the FCAB's suo motu investigation pending the constitutional challenges under the with the Supreme Court with regards to the 2021 update, the council would like to state that the FCAB, though has separate jurisdiction with regards to competition matters, must wait until the Supreme Court decides upon the 2021 update, stating the fact of sequential jurisdiction, Your Lordships. Your Lordships, the sequential jurisdiction has been held in Bharti Airtel case, Your Lordships, when it specifically said that when there is a sector-specific regulator, Your Lordships, then such sector-specific regulator, looking at the very foundational facts of the case, must be given primacy over CCI. Your Lordships, in the present case, the Supreme Court is a constitutional court, which is the only authority that can look into violations of fundamental rights, Your Lordships. And hence, furthermore, Your Lordships, the subject matter that the FCAB and the Supreme Court are looking at are the same. They both are looking at the 2021 update, Your Lordships. Furthermore, Your Lordships, the Supreme Court is looking into whether or not the 2021 update is valid or not, Your Lordships. And such a foundational fact, the validity of the 2021 update itself, must first be determined by the Supreme Court before the FCAB looks into the anti-competitive harm with regards to the Competition Act itself, Your Lordships.
Counsel, I have just one question. When you raise issue 3 with us, what are you seeking from us?
Your Lordships, we are seeking a stay on the FCAB's inquiry until the Supreme Court determines whether or not the 2021 update is valid or not, Your Lordships.
But counsel, the question is, a certain act can have multiple cause of actions.
Indeed,
right?
Your Lordships.
What the Supreme Court has seized off is a different area
Indeed.
of law from
Indeed,
a
Your
privacy
Lordships.
standpoint, and what the FCAB is seeking to look into is purely from a competition perspective.
Indeed, Your Lordships. Indeed.
So you will have to kind of convince us as to why we will have to interfere at this stage.
Indeed, Your Lordships. Your Lordships, at the present matter, concurrent jurisdiction would have been applicable had it not been for the potential contradictory rulings that can arise due to the fact that if the FCAB and the Supreme Court look at this same 2021 update at the same time, concurrently, the Supreme Court could invalidate the proceedings of the 2021 update and declare the 2021 update void. And the FCAB declaring that the 2021 update is an abuse of dominance. Then it would result in the FCAB looking into facts that do not exist at that point in time.
Facts that existed at that point in time, but may have changed at a later point
Indeed,
in
Your
time.
Lordship.
What stops the Commission from actually doing that? Is there a bar on them that they can't look at a competition issue while another regulatory body or court may be looking at a separate independent issue? On the
Your
same
Lordship,
set of
just
facts.
2 minutes to, with regards to the same. Much obliged, Your Lordship. So, Your Lordships, in the CCI, in the Bharti Airtel versus CCI case, the tri-regulator, with regards to the telecom sector, the tri-regulatory authority was also looking at the jurisdictional facts of the case, the foundational facts of the case with regards to certain definitions and certain validity of certain acts, Your Lordships. And there it was held that since TRI is the only regulatory authority that can look at that matter and can look into those definitions, the TRI will be given primacy over the CCI. Similarly, Your Lordships, in the present matter, the Supreme Court the constitutional courts are the only courts that can look into whether the 2021 update is valid or not with respect to Article 21, Your Lordships. And the subject matter of the FCAB's investigation itself is the 2021 update, Your Lordships.
You want to wind up, Counsel?
Indeed, Your Lordships, with regards, with the same counsel, would like to conclude with the arguments. With that, my co-counsel will be dealing with issues 4, 5, 6, and 7. It was an honor arguing before this court.
Appreciate it.
Permission to address the bench collectively as Your Lordships. Much obliged. May my submissions please this Honorable Court. The Counsel too for the petitioner will be dealing with issue 4 and 5 collectively for the benefit of the court and issue 6 and 7 respectively. Your Lordship, it's humbly submitted before this Honorable Court that the 2021 update by Data Now does not amount to abuse of dominance under Section 4 of the Fair Competition Act 2003, nor does it undermine consumer sovereignty. Are Your Lordships with me?
Just give us exactly a minute.
Pardon, Your Lordship.
The one question that we're trying grappling with is why are you addressing questions on merits on abuse of dominance before us?
Indeed, Your Lordship. Your Lordship, the quorum that was set up was not appropriate, and for the same, the Council pleads that the prima facie opinion that was made by the inappropriate quorum was inappropriate, and for the same, the Council will be establishing that there was no abuse of dominance and nor any consumer sovereignty was harmed in the present case, Your Lordship.
Counsel, as a writ court, are we capable of going into these issues, or would you rather argue that as a writ court we may have to address other different issues?
Your Lordship, the Council is arguing these issues only to establish that the prima facie opinion of the abuse of dominance was falsely, and the prayer should also state the same, that it is only to quash and set aside the investigation order passed by the Data Now, and not particularly in terms of determining the position of Data Now in terms of its abuse of non-abusive position in the market, Your Lordship. Much obliged, Your Lordship. The Council will start off by establishing that the relevant market taken by the FCAB under Para 8 is very narrow, and it is only restricted to smartphone market and the OTT messaging market. Your Lordship, for the same, the Council will rely on the case of CCI versus Coordination Committee of Artists and Technicians, West Bengal Films and Television Corporation under Flag 21 of the compendium, Your Lordships, Para 32. Your Lordships, it was wherein said that the objective of defining a market was to identify those actual competitors of the undertaking involved that can constrain its behavior and prevent it from behaving independently of competitive pressures, Your Lordship.
Can you in a minute just tell us the facts of this case so that we have an idea as to why a Supreme Court judgment is being referred to us?
Indeed, Your Lordship. Your Lordship, in the present case involves two associates of artisan and technicians in the West Bengal passed a resolution restraining the members from working with a certain television channel. The CCI in the present case had to define the relevant market and decided that when such...
But Counsel, this is a cartel case.
Indeed, Your
Lordship. You are
Lordship.
in front of us on an abuse of dominance matter.
Your Lordship, the Council is merely relying on this case to establish the fact that the relevant market in the present case needs to be established on the basis of actual competitors in the market, rather than on the fact that where it has more market share, or in the fact that where it can have more dominance, Your Lordships. Your Lordship, the Council contends here that the relevant market in the present case should be consumer communication services, which is inclusive of all the services mentioned by the parties involved under para 1 of the proposition, Your Lordship, when it is inclusive of OTT messaging apps, video calling apps, proprietary apps, and other platforms are also included, that is desktop, smartphones, and which are functionally substitutable for communication and almost are free of cost. Your Lordship, moving on to the fact that if the relevant market is the consumer communication service, the CCI in the Bharti Airtel case has stated that merely providing free services does not itself raise competition concerns unless the same is offered by dominant enterprises and sure to be tented with an anti-competitive objective of excluding competitors in the market. Your Lordship, the Council will now prove that there is no dominance per se in the present case of data now to prove to take the matter for the FCAB to take the matter. Your Lordship, for the same, the Council would like to refer to the case of Sponge Iron Manufacturing Association versus NMDC, flag 22 of the compendium, Your Lordship, para 6. It was clearly stated that the market share alone is not a conclusive test of dominance, and other factors must be considered. Therefore, Your Lordship, in the present case, the Council would like to rely on the factors of extent and efficacy of multi-homing, which is one of the important criteria in a digital market. And the same was established in the Vinod Kumar Gupta versus WhatsApp. Your Lordship,
I'm so sorry if I can just ask, you're before us under what provisions of law?
Your Lordship, the Council is here for the abuse of dominance under Section 4, and there's no...
You've come to this court under what? Are you in a writ court? Are you under...
Your Lordship, we are in the writ court.
Could you just take us to our powers and what you can argue?
Pardon, Your Lordship.
Can you take us to the powers that we have as a court when we are sitting in a writ court?
Your Lordships, the Council here states that the power of the... Your Lordship, the Lordships have the power to direct the FCAB to follow certain procedures that needs to be taken in order to take that prima facie opinion.
Fair enough, and those powers flow from where?
Your Lordship, the power flows from the three writ petitions that are there: certiorari, mandamus, and prohibition.
Fair, and those writs flow from what parts of the statute that you're referring to? Which statute are you referring to?
Your Lordship, the Council is referring to the Competition Commission of the FCAB statute. Your Lordship,
the writs that you speak about are from the Competition Act that you're referring to, or from another statute?
It's from Constitution of India that we are referring to under Article 226.
Can you take us to 226 and explain as to what you're arguing is something we can grant?
Your Lordship, the Council is arguing on the fact that under 226, the
question is whether this is under 226 or 227.
It is under 226, Your Lordship. It's a writ petition before the Honorable High Court of Delhi in order to give a prohibitory and quashing order for the investigation order that is passed by the FCAB in the present scenario. It does not...
Can we go to the relevant statute and have a look at what those powers are?
Indeed, Your Lordship, notwithstanding anything under Article 32, every High Court shall have the power throughout the territories in which it can exercise to issue to any person or authority, including in appropriate case any government, direction, order or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, or any of them for the enforcement of the rights under Part 3 for any other purpose. Your Lordship, in the present case, the Council is relying to issue any orders to any person or authority.
Which writ are you asking us to pass?
Your Lordship, the Council is asking for certiorari, mandamus, and prohibition.
And would you explain what those asks are?
Indeed, Your Lordship.
How are they covered under one or two or all of them?
Indeed, Your Lordship. Your Lordships, the Council is firstly asking for the prohibitory order against prohibitory orders against the FCAB decision to continue with the investigation. Your Lordship, the mandamus the mandamus order, the certiorari order is to quash the investigation order that is being passed by the FCAB to the Director General already. Your Lordship, the mandamus is to direct the FCAB the correct procedure to carry out the whole investigation process in the present matter, Your Lordships.
Sure, please proceed.
Much obliged, Your Lordships. Your Lordship, the Council would move on to establishing the fact that there is no dominance on the basis of the extent and the efficacy of the multi-homing. Your Lordships, the Council will rely on the clarification that was given to us that in order to determine the market share for dominance, we can...
Council, again, like my brother judge asked, when you're going under a writ court,
Indeed, Your Lordship.
you're asking us to pass a direction to quash an order, do we necessarily need to go into the arguments that you're going, or that's the route to go for us?
Your Lordship, the Lordships are not particularly compelled to go through the arguments. The Council is merely making such arguments to prove the fact that the prima facie opinion is not valid. Even in arguendo, the Council will argue on the fact that there is no abuse of dominance per se also, even if dominance is proved by the other party. If Your Lordships is satisfied with the dominance argument, the Council can move to the abuse of dominance arguments.
You can move to the next point.
Much obliged, Your Lordships. Your Lordship, the Council would like to state that the most important factor for determining 42A1 is the unfair and the discriminatory conditions. The Act does not define unfair yet in any of the matters. Therefore, the Council is relying on different cases. The first would be matrimony.com versus Google, Your Lordship, flag 15, para 33, Your Lordships, in which it was clearly stated, indeed, Your Lordships. Paragraph 33, Your Lordships. Your Lordship, it is clearly said that intervention can no longer resolve primarily around the creation or strengthening of market power, but it should focus on the conduct of dominant players and the implication for the competition and commission. Consumers. Your Lordship, the Council will here prove that there is no exclusionary or exploitative practices that was being carried out by data now to show that there is no abuse of dominance. Your Lordship, the Competition Act in its cases has identified the concept of no fault liability, wherein the firm that achieves the superior position of dominance due to efficacy, innovation and quality rather than exclusionary practices, as in Data Now's position is attributable to its robust infrastructure, technology, user-friendly features, and not to coerce or exploit conduct. Your Lordship, even in the Vinod Kumar Gupta versus WhatsApp, it was clearly stated that the CCIs emphasized that the user choice undermines coercion claim. In the present case, Your Lordship, it is clearly stated that if any of the users are not willing to use the app, can simply move to a different app or delete the app. They are not forced to stay with us on the app. Moving on to the second prong, Your Lordship, that there is no denial of market access to the competitors under 42C, Your Lordships. The Council would be relying on the fact that data in itself is not an essential factor doctrine, Your Lordships.
Say that again.
Sorry.
What is not an essential factor?
Data is not an essential factor doctrine, Your Lordships. In the present matter, the Council will rely on the case of Asia Infrastructure Corporation versus Ministry of Railway under flag 23, Your Lordships. The Council would like to take Your Lordships through the facts of the present case in order to draw better attention to the fact that the data is not an essential factor doctrine. Your Lordships, in the present case, the private railway infrastructure, the private railways were not provided the facility to park there in the normal railway stations. The other party contended that the facilities in itself is an essential factor doctrine because the private companies do not have the economy to build the same. In the present case, Your Lordship, the Council contend.
If data is not such an important factor, why are you sharing it with your company, with your parent company, or why is that happening? Why is this data sharing happening if data is not such an important thing?
Your Lordships, the Council is contending that it is not an essential facility doctrine in the sense that the other parties, other competitors, are equally allowed to collect data from the consumers.
Are they able to take data from you, and would you be willing to give data if the data is not important for you, is what my brother judge wants to know.
Your Lordships, the council for the data now completely states the fact that the data with us cannot be shared with the other competitors, but the competitors at hand are not at any point restricted from collecting similar data, and the same was held in this case that the data controlled by data now is not indispensable or indispensable. It can be easily duplicated by other companies who wish to or are willing to have such sort of data, and therefore it cannot be constrained by the FCAB that we are foreclosing market for the other competitors to enter the market. The council will also rely on the telecoms sector report by the CCI in itself that the infrastructure.
Keep also in mind, this is case very old one. This happened 13 years ago.
Your Lordship, the council is merely relying on the case to establish the fact that what are the factors that are considered in order to determine the essential factor doctrine. The Bharat infrastructure provides ample amount of infrastructure to the other competitors to collect similar sort of data, and therefore the act of data now at any point cannot be contended to.
And for your competitors, given the size and resources that you have, the facts suggest that you are a very large corporation with global presence. Would others have that level of information even if they were to go in and collect that data?
Your Lordships, the council has relied on the Asia railway infrastructure for the very same reason, wherein they argued on the fact that they do not have the economic infrastructure to contend the same. Your Lordship, the CCI said that the merely not having economic structure cannot be the basis of the argument. And in the present case, Your Lordship, as the report suggests that the Bharat infrastructure provides other companies equal platforms to collect such sort of data. Connect was having a dominant position is because of the fact that it has been a...
Can you give more context of the report that you cite and how is that relevant for this bench?
Indeed, Your Lordship, the council is merely trying to prove the fact that in Bharat, the competitors have the infrastructure to collect such sort of data, and even if they don't have the infrastructure, the economic hardship cannot be the sole reason to prove the fact that data is an essential facility or it is denying the market access to the other competitors, Your Lordship.
Council, more than your competitors in the market, we are concerned about the users.
Indeed, Your
Why
Lordship.
should users part way with so much information to provide, to use your service? And
Indeed.
also, why should they kind of let you share it with your group companies?
Indeed, Your Lordship.
A user might not want to use other services of your group
Indeed, Your
company. So why
Lordships.
should your group company have that data?
Indeed. Your Lordship, the council will respond to the same in a manner wherein the council would like to explain how the digital economy works. It thrives on data, Your Lordships. Firstly, Your Lordships, the data now do not have the adequate infrastructure to provide such advanced services to the consumers, and that is the reason that the acquisition happened, wherein the ConnectVerse is giving that sort of infrastructure to data now to collect information on a large basis and provide better services to the consumer in itself. It cannot be held to the prejudice of the consumers, Your Lordships. Your Lordships, secondly, the fact that the data is the data is a currency of the digital economy, and the digital economy thrives on data, and therefore, Your Lordships, the acquisition, even the monetary consent.
At one point, you argue that data is not important and anybody can collect it. At another point, you argue that it's the new thing and you really need that data. Can you reconcile that for us so that
Indeed,
we
Your
appreciate
Lordship.
what you're saying?
Your Lordship, the council has contended the fact that data is important. It is the new currency for the digital economy. It is contending the fact that it is not impossible, or it is not physically impossible for the other companies to foreclose the market for data now to collect such sort of data. Therefore, there is no denial of market access for the same. Your Lordship, the council would also like to rely on the case of Fast Track Call Club versus ANI Technologies, Your Lordship, flag 20. If Your Lordships are... Your Lordships, para 90. Your Lordship, it is clearly written the strength of network effect will vary depending upon the nature of the platform market. Large network offers more value to the consumers than smaller networks. Your Lordships, merely contending on the fact that the data now has a better infrastructure or better network effect, it is harming the consumers by collecting data and providing this good services, cannot be said to be in prejudice of the consumers, as it is clearly stated. It depends on the case-to-case basis, and in the present case, Your Lordship, the large network effect is to provide better services, because if both the users and the platform are not on the same platform, the data now cannot provide an advanced level of services that the data now is providing.
Council, we don't really hear competition matters very often. Can you
Indeed.
explain to us in simple terms of what you mean by network effects?
Indeed,
and
Your
what you
Lordships.
mean by things that you're saying in para 19?
Indeed, Your Lordships. Your Lordships, the Council is contending on the fact that the network effect is challenged on the basis of the market share that is there. That is the 500 million users that we have in the market, Your Lordships.
What is network effects is what we want to learn.
Indeed, Your Lordships. Your Lordships, this number of users create a network effect, which means that one person is connected to the other person, and the platform connects all the receivers, senders, and the users in a single platform, which creates a network effect and which ensures that the users connect from one person to another person. Your Lordship, it is to create an instant messaging platform for the consumers, wherein the receivers or users are on the same platform, Your Lordships. If Your Lordships are satisfied, the Council will move to the issue 6. Much obliged, Your Lordships. Your Lordship, it is humbly submitted that the connect verse cannot be subjected to investigation under the Fair Competition Act 2002. The same shall be dealt in two prongs. Firstly, Your Lordship, that the connect verse and data now should abide by the doctrine of corporate separateness, and therefore the one company should not be held liable for the other. Your Lordship, the Council will be relying on the case of Vodafone International Holding BN versus Union of India under Flag 28, Your Lordships. Para 74, Your Lordships, it was held that the legal relationships.
Give us a second.
Indeed, Your Lordships.
Flag 28,
Indeed, Your Lordship, para 74,
74.
highlighted portion.
Please take us through it.
Indeed, Your Lordships. Your Lordship, is stated that the legal relationships between the holding company and the wholly owned subsidiary company is that of two distinct legal persons, and the holding company does not owe the assets of the subsidiary company, and in law, the management of the subsidiary company vests with its board of directors.
Counsel, this matter from the limited pages that you've given us appears to suggest that this was a liquidation proceeding going on against the subsidiary, where
Indeed.
the laws may suggest that you shouldn't go after the parent so that the liquidation effects are not on the parent. Here you are bringing to us a issue that arises from a commission order, where at the end of the day you may have common directors, we don't know, there may be other cross linkages between the parent and the subsidiary. How are you able to explain to us that this judgment of the Honorable Supreme Court is binding on us, given the distinction in fact still?
Your Lordships, the Council has brought up this case only to prove the fact that there is a doctrine of corporate separateness that the competition law needs to abide by, and the same is stated in the Competition Act definition clause itself, wherein it says that wherever the definition.
Are you able to show us a commission order of the Honorable Supreme Court, like a Supreme Court judgment that flows from a commission order where they've taken a view that you can or cannot, bring in a parent of the subsidiary or another High Court bench decision that is on similar facts and issues?
Other than liquidation.
And also-
Other than liquidation,
And
on
also
a commercial
Council,
matter.
in this case, in this factual matrix, ConnectVerse is directly benefiting from the data sharing. Why should the CCI not make them a party to the proceedings? And you will have to kind of explain to us why is that wrong?
Indeed, Your Lordships, the Council shall explain it from the fact that they do not constitute a single economic entity, Your Lordships, in the present, which is an acknowledged factor of the Competition Act.
Counsel, are we suggesting that? Yeah, please. Counsel, are we suggesting that SEE is the only argument to make when you go and impose penalties or investigate a parent company, and if there is no SEE or there is, then you cannot or can go and implead a parent company? Is that the argument that is being made, Counsel?
Your Lordships, the Council will be dealing this issue under two prongs. Firstly, Your
Counsel,
Lordship.
why don't you respond to the question that the bench is asking?
Indeed,
As to
Your
whether you will or will not implead if it is part of the single economic entity or not.
Your Lordship, the Council will plead on the facts of single economic entity and the fact that in Arigando, even if it is proved that they are single economic entity, the Act of ConnectVerse would not infringe any of the provisions of the Competition Act to make a prima facie opinion against.
Council, could you please explain to us what is single economic entity?
Indeed, Your Lordship. Your Lordship, single economic entities are the entities wherein both the company form a part of the same enterprise, Your Lordships. The Council contends in the present case that they do not form a part of the same enterprise and they should abide by the doctrine of corporate separateness, Your Lordships.
So please help us understand.
Indeed, Your Lordships.
User data of one company is being passed on to another company, which is the parent.
Indeed, Your Lordships.
How are they not part of the same group? And what is that meaning of, or what is the definition of enterprise? If we can just go through that
Indeed, Your
first.
Lordship.
And
Your
Counsel, just to take that further, assume after that they are not part of the same group. And if there's another entity which is getting data from the first entity and clearly benefiting from that either directly or indirectly, are you suggesting then that we shouldn't, or the commission shouldn't have gone after that parent entity and implemented? Then what is the locus for the commission to be able to investigate that company who's clearly benefiting, may or may not be part of that single economic entity? Then how do we make sure that people are compliant of laws of Delhi?
The council for the same would be relying on section 5 explanation B of group entity, your lordships. Your lordships, when the facts are silent about the first 2 pointers in terms of the number of assets and the turnover that was acquired, the council is relying on the control of management of the enterprise, which is one of the main reasons how a parent company or any acquired company can be made liable in Competition Act, your lordships. The beneficiary aspect cannot be a ground for the fact that the parent company should be held liable.
So council, para 2 of the proposition specifically says that ConnectVerse is the parent entity, right?
Indeed,
so
your lordships.
How can ConnectVerse be the parent entity of data now? It has to either have shareholding.
Indeed.
It will have
Indeed,
majority
your
of both,
lordships.
or it controls the affairs and management. So are you trying to say that they are part of one single economic entity? Are they part of the same group, or they are not part of the same group?
They are not part of the same group, your lordships. The combination under section 5 is based on certain amount of assets and turnovers.
We're not talking about a combination here, council. We're talking about abuse of dominance.
Indeed.
And where is combination coming?
Your lordship, the council is stating the fact that when are the entities brought under the definition of group
Council, if, let's assume for a minute that they are not single economic
Indeed,
entity,
Your
while the
Lordship.
facts may suggest otherwise, let's assume that. Now, if they're not part of the single economic entity, shouldn't the commission then clearly have brought them in to say, I will want to go after the immediate entity in India, but clearly the entity outside India, the parent, is benefited, so they should also be implemented as a party. Can you articulate as to why the commission was wrong over there without going into this definition of what control under the merger control laws of this commission may be?
Your lordships, the council would contend on the fact that firstly, under the Competition Act, who is benefiting from the data cannot be a ground for making someone liable.
What are the grounds for implementing a party in an investigation, if you could explain that to us?
Indeed, your lordship. In an investigation, the parties can be taken up under 2 grounds. Firstly, under section 3 and section 4 of the Act. Your lordship, there is no agreement per se between the parties.
That's
Therefore,
not
the section
question.
4.
The question, council, is what are the parameters should a council or court
Indeed.
look at to assess if a party should be implemented as a necessary or a proper party?
So section 3 and 4, what you're talking about are the charging sections, right? There's a violation of section 3 or violation of section 4. My brother judge is asking, under what circumstances can you implead a party?
Indeed. Your lordships, the council will draw your attention to section 32 of the Competition Act, which confers extraterritorial jurisdiction only when the conduct creates an abuse in the Indian market of Bharat. Your lordship, the council would plead on the fact that in the present case, this FCAB would not have the FCAB would not have jurisdiction to investigate ConnectVerse.
Council, can we go to section 32?
Indeed, your lordships. Your lordship.
Can we now explain, or can you now help us understand how 32 is inapplicable and why the commission ought not have implemented the outside party?
Indeed, your lordships. Your lordships, the council is relying on the fact that the enterprise that is situated outside India must have an abuse of dominance in India, your lordships. In the present case, the council would rely on the National Stock Exchange of India versus CCI,
Can we stick to the statute and you help us understand as to why 32C may not be applicable over here?
Indeed, your lordships.
Have we said have 26(1), does it say about section 32 at all?
Your lordships, the council would state that any enterprise abusing dominance position is outside India. Your lordship, the council is contending that there is no abuse of dominance by ConnectVerse in India. Therefore, FCAB's jurisdiction does not draw to a company which is situated offshore and creating having no.
That if there's a party outside India, has no presence in India, but there's a subsidiary of that party in India, or 100% or a 51% subsidiary, that will mean that, that the commission can never then implead a party outside India because they're physically not present. They themselves never took any actions. They were not on a board of that company, but still you're saying you cannot.
Even if we are sharing data with them.
And maybe a major shareholder and therefore profiting from the data share.
Your Lordships, the FCAB has created these provisions to assure that none of the companies outside India or India can get away with any of the abuse or dominance that they create within India, Your Lordships. Your Lordships, in the present case, in order to determine the ConnectVerse decision, a proper flow of decisions that needs to be taken. Firstly, Your Lordships, the group entity factor that was needed to be clarified, wherein in the Meru Travel Solutions versus ANI Technology, it was stated the section 4 does not recognize collective dominance, Your Lordships. Secondly, Your Lordships, the ConnectVerse in the present case could have been only liable when it is abusing dominance in India, which is clearly not possible because, Your Lordships, the section 4.2e, Your Lordships.
Yes.
Your Lordships, the council is contending that that 4.2e requires the presence of two relevant market and the foreclosure in the second market in the Bharat. DNT operates only in the OTT messaging platform, whereas the ConnectVerse is a separate legal entity operating offshores with least interaction with the conventional market of Bharat. Only because of the fact that they are technically searched or like that the ConnectVerse is.
Council, take a minute and wind up, please.
Your Lordship, the Council would like to state a case of Scott Glass India versus Competition Commission of India. Your Lordship, in that case, para 60, page 81, the relative advantage which enhances consumer welfare may coexist with the market power and should not be condemned. Your Lordships, the ConnectVerse or data now in the present case is merely at a relative advantage position and is not at any point abusing consumer welfare. Your Lordships, if 2 minutes can be granted to complete issue 7.
Take a minute more and finish issue 7. Exactly a minute more.
Indeed, Your Lordships. Your Lordships, issue 7, there is a clear argument on the fact that there needs to be an actual foreclosure of competition or there must be a demonstrable anti-competitive act under an effect-based approach in order to make price and information asymmetry non-price parameter in the present case. Your Lordship, the Council clearly contends the facts that as the Council has already proved that there is no foreclosure in the market, the price of the information asymmetry cannot be considered as a non-price parameters for the market.
We've taken this on record.
Much obliged, Your Lordship. If Your Lordships are satisfied with the issue, the Council would like to move to the prayer.
We've taken note of your prayer already.
Your Lordship, it was my honor arguing before the court.
Now, the team bearing code 37 shall present arguments for the respondent sides for the total period of 60 minutes with 10 minutes reserved for the rebuttals. The first speaker of TC 37 will speak for 28 minutes.
Greetings, members of the esteemed panel. The Council seeks permission to address the bench collectively as Your Lordships and individually as Your Lordship. Much obliged, Your Lordships. Your Lordships, the matter that we are gripped with today is an excellent example of how frivolous suits are filed against quasi-judicial authorities to delay investigation and procedures into matters that are very important for the public of the country. Your Lordships, if you're well versed with the facts of the case, the Council seeks permission to proceed with the submissions. Right, Your Lordships. Over the course of the next 60 minutes, my learned co-counsel and I, in all our endeavors, will convince the court that the actions that FCAB has taken under the Fair Competition Act of Bharat is valid and legally tenable. For the same, I shall be arguing on 3 issues. First being that the action that the Fair Competition Authority of Bharat has taken under section 26(1) is legally tenable. Secondly, the petitioners herein have no legal right to get a notice or hearing at the stage of formation of prima facie opinion. And lastly, FCAB need not exercise any regulatory restraint. Proceeding with my first submission, Your Lordships, the investigation order that FCAB has issued under Section 26(1) is legally tenable for three primary reasons. First being the application of Section 15 given the circumstances. Second being the scheme of FCA does not provide a blanket quorum requirement. And third being the tenability of the application of doctrine of necessity given the circumstances. Proceeding with the first prong of my submission with respect to issue 1. Your Lordships, any vacancy or defect in the constitution of FCAB does not invalidate its proceedings is what Section 15 clearly outlines. Your Lordships, Section 15 has been repeatedly argued and upheld in cases like CAD systems, in cases like ADIF versus CCI, a very recent judgment back in 2023, and herein, even when there was a vacancy on the bench of FCAB, such vacancy did not invalidate the proceedings of FCAB, especially under Section 26(1). And therefore, Your Lordships, the Council submits that given the fact circumstances, given the scenario of the proceedings, as has been outlined in paragraph number 10 of the moot proposition, Your Lordships, the order under Section 26(1) is legally tenable even if there was a lack of quorum. Your Lordships, proceeding with my argument with respect to blanket requirement of quorum in the scheme of Fair Competition Act, Your Lordships, apart from Section 22, if we go through the provisions of the Fair Competition Act, there is complete silence with respect to quorum. Your Lordships,
Isn't 22(3) very clear, Council, on especially the proviso that was already highlighted that there shall be quorum?
Right, Your Lordships. Your Lordships, when we come to the proviso of Section 22, Clause 3, Your Lordships, that is restricted to administrative matters, firstly, as has been clearly outlined.
So, Council, you are arguing that for administrative matters there ought to be quorum, but for judicial matters there may or may not be quorum. Therefore, you may not, as the Commission, have the powers to launch an investigation, but you definitely have the powers to investigate and then penalize a party up to 10% of the turnover of the party.
Definitely not, Your Lordships. Your Lordships, if I may draw your attention to this particular case, ADIF versus CCI. In this case, Your Lordships, the interpretation of Section 15 was taken in the sense that Section 15 starts with any act or proceeding.
You have copies of the orders and judgments that you're referring to?
Your Lordships, I'm so sorry, we haven't been able to furnish the same to Your Lordships. However, I can direct you to the exact paragraph of the judgment, and if I could just give my relevant material to you.
Do you have a copy for yourself?
No, but I could just refer that to you. I know what I'm arguing, Your Lordships.
We'll manage.
All right, Your Lordships. Your Lordships, so in para 67 of the relevant case, what was held by the court was, in Section 15 it states no act or proceeding. So act or proceeding would mean administrative and adjudicative two functions. However, the use of the word or in act or proceeding means that Section 15 applies to both administrative and adjudicative functions, and therefore Section 15 acts as a savings clause, be it administrative, be it adjudicatory, any function. Now it's upon the courts to classify formation of prima facie opinion as being administrative or adjudicative. That is not what the Council is dealing with. However, the Council submits that in light of the established precedents, both administrative and adjudicatory functions of the FCAB is covered by Section 15, which acts as a saving clause, and therefore what FCAB has done given the circumstances is legally tenable. If Your Lordships are satisfied with the answer, I'd like to proceed with my further submissions. Your Lordships, coming to blanket requirement of quorum in the FCA. Your Lordships, if we go through the provisions of the FCA, the scheme of the FCA, Your Lordships, there are sections like Section 6(2)(a), of course Section 26(1), the impugn provision. These sections would become defunct if there is a requirement of quorum. Moreover, Your Lordships, Section 15 is an enabling provision.
Could you explain as to why it will become defunct if 6(2)(a) comes into play?
Right, Your Lordships. Lordships, Section 6(2)(a), as it reads, no combination shall come into effect until 150 days have passed from the day on which notice has been given to the Commission. Your Lordships, if there's no quorum in the Commission and if a notice has been given, it could very well be argued that the notice was not served well due to lack of quorum, and because of that fact, Section 6(2)(a) would become defunct. So,
Counsel, are you arguing that if a notice is filed and quorum isn't there, it's defunct or it's invalid as of the date of filing?
Your Lordships, exactly my point. Your Lordships, that could be an argument that could be taken in any case if Your Lordships take this argument and accept the fact that that quorum can be extended beyond Section 22 and could be applied to other provisions of the FCA as well. Your Lordships, what the Council is contending is that the scope of quorum is restricted merely to Section 22, and that is what the scheme of FCA says by virtue of provisions like Section 6(2)(a).
So, Counsel, there can then be situations where the chairman and members of this commission may actually be on duty outside and therefore not in quorum as of the date of filing, and then the filing itself is made redundant is what we are arguing.
Very well, Your Lordships. That could also be a case, and that is why I am saying that quorum should not be extended to all other provisions of FCA and should be limited to Section 22. That is exactly the line of reasoning that the Council is contending, Your Lordships.
Proceed.
Right, Your Lordships. Having established the scheme of FCA and the fact that Section 15 acts as a savings clause to Section 26(1), the Council is of the opinion, if Your Lordships are in consonance with the same, that the application of doctrine of necessity is an ancillary issue that might not be very relevant here because of the fact that the court is already in agreement with the actions under Section 26(1). Therefore, the Council seeks permission to proceed directly to issue 2. Much obliged, Your
Counsel,
Lordships.
just like to kind of stop you here for a second. You were talking about administrative role of the commission, and you were trying to distinguish that the requirement only applies to administrative role and not the judicial powers when they exercise judicial powers, right? And then you're referring
Your
to-
Lordships, I'm so sorry to cut you. However, Your Lordships, I am saying that be it administrative, be it adjudicative, there's a distinction that has been created, but despite that distinction being created, the use of the word or in Section 15 means that Section 15 would apply to both administrative and adjudicative functions of the Fair Competition Authority of Bharat, and that is why, given the circumstances, Section 15 would act as a valid savings clause to Section 26(1).
Okay, so then like the fact that you're talking about a regulatory power of the CCI under Section 6(2), it kind of wears the hat of a regulator. It is not a judicial function where an application is kind of filed with the CCI asking for CCI's permission to kind of go ahead with the transaction. Where will you fit that?
Exactly, Your Lordships. That is my point, that even in 6(2)(a), Your Lordships, I get a question. If I get you correctly, you mean to say that regulatory functions would not fall under, say, administrative and adjudicatory functions, and that is why where would regulatory powers under Section 6(2)(a) fall? Your Lordships, in my opinion, Your Lordships, regulatory powers of the FCA would again come under the parameters of administrative functions because the primary distinction that's created between administrative and adjudicatory function is the application of judicial mind. Your Lordships, in administrative functions, in the humble opinion of the Council, application of judicial mind is relatively much lesser than while discharging adjudicatory functions, and therefore, Your Lordships, in the humble opinion of the Council, the powers related to Section 6(2)(a) being less with reference to application of judicial mind would fall under the parameters of may not be tight compartments. However,
So, Counsel, are you saying that like regulatory function falls within the ambit of administrative? So there is a quorum requirement for it because that's exactly what the ADA in the High Court in ADIF matter is said.
Lordships, I beg to differ with you on that point. Your Lordships, in ADIF matter, the courts have held that quorum does not apply to adjudicatory functions, but they have never said that quorum would apply to administrative functions. That's just an extensive reading that the petitioners here have tried to push. If I may refer you to paragraph number 76 of the ADIF judgment, for the sake of assisting Your Lordships, I would like to read the words of the judgment. It states that Section 15 acts as a saving clause in regard to a situation where a vacancy or defect in the constitution of the CCI would arise, and any such vacancy or defect in the constitution would not invalidate any proceedings so far as adjudicatory powers of the CCI is concerned. So they have clearly ruled with respect to the adjudicatory powers of the CCI. However, with reference to administrative functions, there's no settled law of the land. Moreover, Your Lordships, ADIF versus CCI is a single judge decision of the High Court at Delhi, which does not bind the 3-judge bench that the Council is arguing before. If Your Lordships are satisfied with the submission, the Council would...
Please proceed.
Right, Your Lordships. Proceeding with my submissions with respect to issue 2. Your Lordships, FCAB is under no legal obligation to issue any prior notice or afford an opportunity of hearing to the petitioners, because firstly, the governing law, which is the FCA, does not prescribe any such requirement. Secondly, audi alteram partem cannot be invoked. And lastly, even if it is invoked, the actions of FCAP are protected under Section 15C. Your Lordships, firstly, Section 26(1) does not contemplate any rights of hearing or notice to the petitioners. Your Lordships, if we go through the words of Section 26(1), it clearly in no way mentions that there needs to be any right to hearing or notice that needs to be provided to the parties merely at the stage of formation of a prima facie opinion. It also refers to Section 19(1). However, even Section 19(1) does not prescribe any such right. Proceeding forward, Your Lordships, the famous principle of interpretation of statute is expressum facit cessare tacitum. Your Lordships, this principle means that express mention of one thing implies exclusion of another. Essentially, expression precludes implication. Your Lordships, if we go through sections like Section 26, Clause 7, Section 26, Clause 8.
Yes.
If Your Lordships are with me, therein, Your Lordships, the provision of providing notice to the parties has been given. Moreover, Your Lordships, Regulation 21(8) of the general regulations dealing with competition matters also provide the right to notice to the parties. However, apart from these...
Which regulation are you referring to, Counsel?
The general regulations.
Which one?
Your Lordship.
Which regulation?
Regulation 21, Clause 8.
Clause?
8.
21(8) of
Right.
the general regs.
Right.
You want to take us through that?
Right, Your Lordships. Your Lordships, the regulation reads, on consideration of the objections or suggestions from the central government or the
Counsel,
state
you're reading 21(8) of the CCI general regulations of 2024.
2009, Your Lordships.
Why?
It's been amended.
Why are you taking us through something which is not good law now?
I'm sorry, Your Lordships. Probably I have not taken into account through a fallacy because of the fact that I'm so sorry, Your Lordships. The council is unaware about the 2024 regulations.
Counsel, you're referring to regulations that the bench is looking at. We ask you to take us through that. Only then do you realize that the regulation does not exist. Can you get hold of an act and explain to us as to how 21(8) is applicable or the corresponding provision under the new regulations?
Your Lordships, regardless of Regulation 21(8), the argument would still stand. Your
Also,
Lord,
we'd like to see what you are arguing. Can you take us to 21(8) or?
right, Your Lordships. So, Your Lordships, 21(8) reads as follows. On consideration of the objection...
Can you look at the new regulations and take us through the new one so that we know that you and I are referring to the same thing?
I'm sorry, Your Lordships. The council at the moment does not have the new regulations.
Can the court master please pass this to the council? You withdraw this point and move on, counsel?
Oh, definitely, Your Lordships. Your Lordships, regardless of Regulation 21(8), Your Lordships, the other provisions of Section 26, that being Section 26(7), Section 26(8), provides the right of notice to the parties impugned therein. However, Your Lordship, Section 26(1) does not provide any such right. Therefore, Your Lordships, when the legislature has expressly mentioned such right of notice...
So when you mention the right of notice under 26(7), can you explain where that's captured under 26(7)?
We certainly hope you're looking at the correct regulations. Are you still looking at 2009?
Your Lordships, the Council would like to withdraw this particular argument and proceed with further arguments. Much obliged, Your Lordships. Proceeding further, Your Lordships, the principle of audio alteram partem cannot be invoked as it is excluded impliedly by the FCA and it is excluded by the virtue of invocation of doctrine of necessity. Your Lordships, audio alteram partem is excluded impliedly by the Fair Competition Act. Your Lordships, the precedents establish that principles of audio alteram partem can be excluded when having regard to the nature of the action taken and the purpose and the scheme of the relevant statutory provisions, such exclusion is warranted by the Act. Your Lordships, the nature of the Act under section 26(1) is merely administrative. Your Lordships, these do not determine the rights of the parties to the list and do not affect the substantive rights of the parties, and this was established in CCI versus SAIL.
Can you take us to the relevant provisions of SAIL that suggest that
Right,
this
Your
is
Lordships.
administrative?
If I may draw your attention to paragraph number 38 of CCI versus SAIL. Your Lordships, therein the Supreme Court has held that it is merely an administrative direction to one of its own wings departmentally and is without entering upon adjudicatory process. It does not effectively determine any rights or obligations of the parties to the list. Therefore, having regard to the nature of the act that is done by the FCAB under section 26(1), principles of natural justice, that being audio alteram partem, can be and should be excluded. Proceeding further, Your Lordships, it is a settled jurisprudence of law that doctrine of necessity, when invoked, excludes application of principles of natural justice. Herein, Your Lordships, the doctrine of necessity was invoked, and therefore, the principle of natural justice, that being the right to provide notice or hearing to the petitioners herein, should be excluded. Proceeding further, Your Lordships, if Your Lordships are not convinced with my submissions with respect to provision of rights of notice or hearing, the Council would like to argue on section 15C.
Yes.
If Your Lordships are with me, even if the petitioners contend and the court happens to accept the fact that the procedure provides for the right to notice to the parties, section 15 again acts as a saving clause wherein it provides that any irregularity in the procedure of the commission which does not affect the merits of the case would not make the particular procedure invalid. Your Lordships, here cleared in merits of the case is not affected because this, as established in CCI versus SAIL, is merely an intra-departmental order that does not determine the rights of the parties, that do not affect the rights of the parties, and therefore section 15C could be taken as a savings clause with respect to the procedure of audio alteram partem prescribed herein. If Your Lordships are satisfied with
Do you have any other judgments of the Supreme Court that bind us to say that even if there is an irregularity, I still should not interfere or do something because that's okay under 15C?
Your Lordships, the Council at the moment does not have precedents of the Supreme Court that binds this court. However, Your Lordships, the Council is aware and asserts the fact that there is no contrary precedent of the Supreme Court that states that section 15C could not be used given the circumstances of the case. Therefore, Your Lordships, this again lies as an unsettled position of law, which Your Lordships could settle with the help of this judgment.
And do you have any other precedents of the Supreme Court that's beyond competition law, but again suggests through the fact that if there's a procedural irregularity that can be dispensed with for the larger good in terms of a similar clause like 15C?
Your Lordships, I do have judgments with respect to Electricity Act, but that pertains to section 15. Generally section 15A with respect to quorum and not with respect to 15C. However, if you read quorum as a procedural requirement, then those judgments with respect to Electricity Act would also come into picture.
Which judgments are we referring to? Can
Right,
you
Your Lordships.
help us understand?
Your Lordships, the judgments are Faridabad Industries Association versus Haryana Electricity Regulatory Commission and Amosi Industries Association versus Uttar Pradesh Electricity Regulatory Commission. Your Lordship, section 15 of FCA is in pari materia to section 93 of the Electricity Act of 2003. Therefore, Your Lordship, the equivalent of FCAB under the Electricity Act, that being APTEL, had proceeded and made certain orders when there were less than 3 members. Simply 2 members on the bench. Therefore, they had not fulfilled the quorum requirement that was same as 3 in the Electricity Act, And that even therein, the courts had upheld the order that had been passed by APTEL by virtue of Section 93.
Can the bench get a copy of 93.3 so that we can peruse?
Your Lordships, Section 15 is exactly
Fair.
in same. Right, Your Lordships. If Your Lordships are satisfied with my submissions with respect to a concurrent statute, the Council seeks permission to proceed to issue 3. Much obliged, Your Lordships. Your Lordships, FCAB is not required to exercise judicial restraint because FCAB's investigation is distinct in its scope and it is empowered under Section 62 of FCA to conduct independent inquiry. Your Lordship, the scope of inquiry that FCAB is conducting, given the circumstances, is very different from the inquiry that is being conducted is very different from the case that is being dealt by the Supreme Court of Bharat. One deals with an abuse of dominance, which is an anti-competitive antitrust matter. On the other hand, the Supreme Court of Bharat is dealing with violation of fundamental rights. Both of these pertain to very different issues.
Counsel, what is the underlying act that both these authorities are trying to kind of look into? It is sharing of data or extracting more data. So how are you saying that these are completely different domains?
Right.
Because the underlying act is the same. A company trying to gather more information and more data about Indian users.
Indeed, Your Lordships.
And that issue is currently seized off before the Supreme Court. And what gives your client the ability to look into it? If the Supreme Court were to kind of decide that this is not a fundamental right violation, right, then there is no cause of action for you to look into a competition law issue.
Indeed, Your Lordships. Your Lordships, the Council contends that a privacy matter and an anti-competitive matter is very different. Even if the Supreme Court tomorrow goes on to hold that this is not a violation of fundamental rights, that does not mean that it cannot be an anti-competitive conduct. It could still be an anti-competitive conduct. It could still warrant an inquiry by the FCAB given the circumstances. Also, Your Lordships, even though the act of FCAB or even though the act of the petitioner is same, the statute dealing with the two is different. One is the Bill of Rights under the Constitution of Bharat. Another one is the Fair Competition Act of Bharat. One inquiry pertains to inquiry under Fair Competition Act, which would follow parameters established under the Fair Competition Act. The other one deals with parameters established under the Constitution of Bharat. Moreover, Your Lordships, even if tomorrow the court goes on to hold that this is a violation of fundamental rights and strikes down the policy, that does not bar my client from inquiring into abuse of dominance, because that policy is something that has been brought up by virtue of its by virtue of the dominant position of the petitioners and abuse of the said dominance. So the policy has been brought up, and that itself gives my client the authority under Section 26(1), that being an ex post law, to do an inquiry.
Counsel, if it is not, if the Supreme Court has kind of spoken its mind and said that this is not erosion of privacy, what is the underlying issue that you're trying to regulate under competition law? Because under competition law, what I understand from the proposition is you're saying that collecting a large amount of data amounts to a non-price factor or a non-price abuse. So how are you, what are you trying to kind of fix? What is your client trying to regulate or fix?
Your Lordships, when it comes to Section 4, abuse of dominance, Your Lordships, my learned co-counsel would be more apt to deal with it, and he would do so in the course of arguments. However, for the satisfaction of the court, I would like to state a judgment wherein it was clarified when there's a specifically in Bharti Airtel, Your Lordships, in that case, the matter dealt with two sectoral regulators and not between a sectoral regulator and a court. So a principle of Bharti Airtel could not be used here, because there was a sectoral regulator and a market regulator. Here there's a market regulator and a court, and both of them can investigate parallelly. Moreover, Your Lordships, no investigation can ouster the jurisdiction of the constitutional courts. This has been established in Chandrakumar versus Union of India, wherein it's held that the jurisdiction of the constitutional courts forms a part of basic structure of the constitution. So therefore, if the Lordships hold that, okay, FCAB should continue inquiry, where if Your Lordships hold that the constitutional inquiry should go on and FCAB should wait herein, then Your Lordships, that would highlight the fact that a court's inquiry is given, that a court's inquiry is held significant, and clearly the inquiry done by the sectoral regulator, by the market regulator, is of no significance, which should not be the case.
Counsel, why don't you wrap it up? We have just 2 minutes.
Right, Your Lordships. So, Your Lordships, given the overlapping jurisdiction, Your Lordships, FCAP should have complete authority over anti-competitive matters because, Your Lordships, in the jurisdiction of Bharat, there is no other authority equivalent to FCAP that can look into anti-competitive market and into anti-competitive activities and abuse of dominance, and therefore the jurisdiction of the FCAP is exclusive to that of the courts. Moreover, Your Lordships, Section 62 of FCA states that there should be a harmonious construction of the law, harmonious application and enforcement of the Fair Competition Act, unless it's in derogation of the other statutes. Clearly, Your Lordships, Fair Competition Act is not in derogation of Article 21 of the Constitution of Bharat, and therefore, Your Lordships, even Section 62 allows Fair Competition Authority of Bharat to proceed with its investigation under Section 4. If Your Lordships are satisfied with my submission with respect to jurisdictional issues, the Council thanks Your Honours for your time and your active listening to my arguments and hands over the dais to my learned co-counsel.
Lordships, the Council seeks the permission to refer to the bench collectively as Your Lordships and individually as Your Lordship. Much obliged, Your Lordship. Greetings to Your Lordships. Moving forward with the scaffolding provided by my learned co-counsel, I, as the second counsel for the respondents, will be dealing with issues 4 and 6 first, then moving over to issues 5 and 7 over the span of next 27 minutes. The Council seeks the permission to begin submissions on issue 4.
4 and 6 is what you say?
Affirmative, Your Lordship.
Unfortunately, you don't have 27 minutes, so you will have to kind of compress it.
Definitely, Your Lordship. I will try my best. The Council seeks the permission to begin the submissions on issue 4, Your Lordships. Much obliged. Lordships, in terms of issue 4, it is submitted that the conduct of data now squarely amounts to an abuse of dominance under Section 4 of the Fair Competition Act 2003. Your Lordships, such a claim has been substantiated by way of a two-pronged argument. Firstly, that data now does occupy a dominant position in the market, and secondly, it meets the threshold of dominance, of abuse of dominance in terms of Section 4 and Section 19. Lordships, beginning with the first prong, it is submitted that data now holds a dominant position in the market. Lordships, for this particular submission, Section 19, Clause 4 of the Act will be instructive in this regard, and for the ease of the court, I will begin by reading out the provision. Lordships, it states that the Commission shall, while inquiring whether an enterprise enjoys a dominant position or not under Section 4, have due regard to all or any of the following factors. And then, Your Lordships, the statute goes on by enumerating 13 such clauses. Lordships, careful attention must be drawn to the language that this provision entails. It states that all or any of the factors may be taken into regard. Lordships, this in itself shows the legislative intent behind the enactment of this provision. Had the lawmakers not intended for one provision to be determinative of the fact that one entity is dominant in the market, such a wording would not have been used in the first place itself. Lordships, in the present fact scenario, data now has almost 500 million users, and that too within the Republic of Bharat. We are not sure of how many users they have internationally, but in our area of jurisdiction, they themselves have 500 million users. Lordships, in the case of Harshita Chawla versus WhatsApp, specifically paragraph 24, it was held that WhatsApp enjoys a dominant position in the market, having a pre-existing user base of more than 400 million users in India. Lordships, furthermore, in another set of petitions that was held against WhatsApp after the 2019 and 2021 policy updates, the case was of public version versus display where the ad is relevant. Lordships, in paragraph 55 of that case, it was stated that market share is a key element for understanding market structure and the relative importance of the competitors within a relevant market. It further stated that consistently high market shares reflect substantial competitive advantages, such as the ability to leverage presence in neighboring markets, economies of scale, and high network effects. Lordships, in the present case, as stated earlier, data now has almost 500 million users within the Republic of Bharat. With this, it has created strong network effects. And also, Lordships, if we consider the argument regarding multi-homing as was put forth by the petitioners, Lordships, Just by the fact that multiple people are there on multiple platforms, that in itself cannot deny the fact that data now in itself has 500 million users, and it's a fact of matter that such a market share is determinative of the fact that it is a dominant entity in the market. Lordships, furthermore, that regarding network effects, data now is essentially a messaging platform. So I, as a consumer, have no option, as in, even if there are multiple players in the market, but I really have no other option to go to any other player if my other contacts are not on that other platform. So even if the argument of multi-homing is considered, the claim of dominance and the claim of a dominant position of data now cannot be negated with this.
Counsel, just one context. The petitioners are before us under 226. We would typically not interfere. Would you explain as to how you're arguing that by under 6 or 7, or under 4 and 7, 4 and 6?
Lordships, could you clarify 4 and 6?
Your issue number 4 and issue number 6?
Lordships, Article 226 might not give this court the jurisdiction, but Article 227 does give it, and supervisory matters and direct the conflict in this regard. If that suffices, may the counsel proceed?
Do you want to argue or explain maybe now or in later course as to why we should not interfere at this stage?
Lordships, the procedural aspects of it regarding the maintainability of this petition from the side of FCAP has been dealt with my learned co-counsel. I will be establishing the fact that whatever findings have been done on record and whatever the factors regarding triggering of the antitrust liabilities have been on there, that is what I am trying to establish in the course of my arguments. So if that is okay. Lordships, regarding the second prong of the argument, it is submitted that the conduct of data now does meet the required threshold of abuse under Section 4. Lordships, such a claim has been substantiated by way of a four-pronged argument, and I will be dealing with them one by one. Firstly, Your Lordships, regarding Section 4(2)(a), it states that there shall be an abuse of a dominant position if an entity directly or indirectly imposes unfair or discriminatory conditions. Lordships, it was held in Shamsher Kataria's case. So basically, this was a case wherein Shamsher Kataria, the petitioner, he sued multiple automobile giants such as Volkswagen, Honda, and Fiat, wherein they were restricting automobile spare parts to other non-authorized dealers, and such a conduct by these automobile giants was held to be violative of Section 4(2)(a). Lordships, in the present case, the petitioners are giving the fact that you either consent to our terms or you leave the platform. That in itself shows the fact that this is an unfair condition upon all the users. The real choice that they have is either you comply or conform with the exploitative terms and conditions of a technological giant, or you simply stop using the app. The respondents fail to understand, Your Lordships, how in any manner can that not be unfair. This clearly shows the fact that the conduct of data now is unfair in terms of Section 4(2)(a). Lordships, I feel some hesitance, or the Lordship. Definitely. Thank you, Lordship.
I have a question for you.
Definitely, Your Lordship.
The users are aware that this is a product that is available either for a price or for free of charge. And if the users are well aware the price by way of data or through Indian currency or whatever the denominator currency is the value that value exchange that has to happen, and they walk into this contractual arrangement with eyes wide open, why should the competition authority interfere as to how much data is being shared? It's as good as like a transaction happening between two parties for, let's say, X rupees or X dollars. The commission would not interfere in that sort of a transaction. So why is this very different? And I mean, to us, it appears to be a regulatory kind of overreach.
Definitely, Your Lordships, that's a very valid question. I would attempt to answer that question. Lordships, the fact that data is being collected from consumers, and also data, another extension to that is data is being collected by data now and then is being funneled off to its parent entity. Your Lordships, the fact that antitrust liabilities have been attempted against the petitioners is because of the fact that ConnectVerse is also a corporate entity which has a larger digital ecosystem, and the fact that the data that is collected by data now is being funneled off to them without really considering its ramifications or effects on the consumers. That is what that data now is. Lordships, this is also a claim under Section 4(2)(e). That is, data now is technically trying to traverse into another market through that. So the fact that data now is using its dominant position in one market, trying to assert its parent's dominance into another market, that is what is bringing this matter before this court, Lordships.
It doesn't answer my question of why, for example, I'll give you a simpler example. If let's say one entity of Tata, let's say Air India, were to kind of fund another group company, extend current, let's say, monetary support or financial support to another group company, would the CCI kind of interfere with that? Because it's like, there's been a value exchange between passengers and Tata, so they've amassed certain amount of wealth or financial strength, and then they're passing it on to a group company. So that is not a concern of the Competition Commission. And if you were to superimpose the same template onto a data economy, where certain services are being provided free of cost, right? Users are enjoying those free of cost, and that doesn't come without any cost attached to it, right? So there'll be somebody who will have to pick up the bill for that. So the way the users are paying back is through their data, and if that data is going to be used for advertising and to kind of run the machinery, so where do you come in, and how is the authority determining this much is too much as far as collection of data or sharing of data? Will it not be the discretion of the user? I mean, as a macroeconomic regulator, should your client not be worried about these sort of issues? And there are much bigger issues to work on.
Lordships, the fact that in today's contemporary world, wherein communication services such as by the petitioners, by entities like Data Now, they form the very basis of how people communicate in today's world. And your Lordships, data collection was not a part of Data Now's policy prior to the acquisition by ConnectVerse. And the ambit of data now, and the ambit of data collection has also increased right after the acquisition. Following 2016 and 2021 updates, the quantum that Data Now is collecting from its users has substantially risen ever since. So, your Lordships, this is what brings this matter before your Lordships, the fact that data is being sure that this market is a non-price market, but users are paying with their privacy, your Lordships here. Had it been a monetary consideration, it's still something that you can gain back. But privacy, as a matter of fact, your Lordships, once it's gone by, it's taken away by a technological giant. By that, a consumer cannot even trace where is his information going. Once Data Now transfers the user data to ConnectVerse, there is no trace that the consumer can take.
No, I'm not understood. You are with the you are arguing for data privacy, or this is for competition? I mean, I'm a little confused here.
I would like to clarify, Lordship, the fact that Data Now is collecting data from users, funneling it off to the parent entity, which is ConnectVerse, is a violation of, Lordships, the fact that 4.2e is being violated here, that's trying to leverage itself from one market into another. And that's what my submission would be if your Lordship
that the Supreme Court currently is looking into, whether this would amount to violation of fundamental right to privacy. I mean, that is exactly what the Supreme Court has seized of. And we're kind of struggling to understand where does the Competition Commission fit into this entire equation.
Your Lordships, I would again harp back on the fact that Section 4.2e of the Act, it states that when a dominant entity uses its position or leverage it in one market to enter or protect another, that shall be considered an abuse under the Act. And that is what brings this matter before this court, Your Lordships. With your permission, with the Council. Much obliged, Lordship. Lordships, in CCI's order against Meta, imposing a more than 200 crore penalty, it was held that the dominance in the messaging space of WhatsApp was being used to leverage the authority and the dominance of Meta in the online advertising space. Similarly, Your Lordships, in the case of matrimony.com versus Google, specifically in paragraph 38, the court held that Google was creating an uneven playing field by unduly favoring its own services, and Google was leveraging its strong position in various online searches to enter into and enhance into position into ancillary other markets. So basically, Your Lordships, Google here was also, like the conduct of Data Now is similar to what Google was doing in the matrimony case. They are using their dominance in one particular market to reinforce their position into another set of market, which is what is a contravention of Section 4.2e, Your Lordships. Your Lordships, if the bench is satisfied on issue 4, the Council seeks a permission to continue with issue 6. Much obliged, Lordships. Lordships, under issue 6, it is submitted by the Council for the respondents that FCAB was justified in impleading ConnectVerse in this investigation. Such a claim has again been substantiated by way of a two-pronged argument. Firstly, that Data Now does not have an independent entity, and secondly, that it satisfies the test of enterprise liability. Beginning with the first submission, Your Lordships, it is submitted that in Balwant Rai Saluja's case, the Supreme Court held that corporate veil from over two entities can be lifted and pierced if it is used to evade a legal obligation, or let's say to cause excesses in the market, or to basically use the corporate restructuring as a matter of a facade. Lordships, in the present case, ConnectVerse acquired Data Now. And ever since Data Now has been a subsidiary of ConnectVerse. So Lordships, when a holding company exercises managerial, administrative and operative authority over the subsidiary, it cannot be assumed that the subsidiary is acting in complete isolation and not under the influence of the parent company. Your Lordships, furthermore...
Can you explain as to why you couldn't have achieved the same objectives by not going after the parent entity but going after the entity in charge in India? Is this being done to increase your penalties that you may eventually want to impose, or is there any other logical reason that you have for ConnectVerse to be implemented as a party?
Your Lordships, firstly that ConnectVerse is a direct beneficiary in this arrangement. In Facebook's case also, when WhatsApp and Facebook were against WhatsApp, when Facebook was implemented, this was the very fact that the court took into regard that whatever data was being collected, it was directly being funneled off to Facebook.
What are the factors that you considered when you implemented ConnectVerse as a party?
Lordships, first that it was a direct beneficiary of the data that was being collected. Secondly, that Your Lordships, that it's the parent company, it's the holding company of a subsidiary. And thirdly, that it's a logical assumption that the respondents here make by the fact that Data Now, Your Lordships, was a successful enterprise ever since its inception. It had been functioning with utmost popularity, and as the petitioners have also stated in their case, that it created strong network effects for itself. So, Your Lordships, in such facts and circumstances, it does not make sense for a dominant entity like Data Now to bring in two policy updates, which, rather than bolstering their position in the market, brings backlash to them.
So, are you suggesting the backlash is because of ConnectVerse and not because Data Now itself wanted to do that?
Lordships, I would like to clarify the fact that policy updates have been brought. It's not on Data Now's own record, and it's deliberately done to ensure that these policies can be aligned with the overarching the interests of the parent company, which is ConnectVerse. Because as far as Data Now is concerned, they have no reasons to weaken their position by bringing in such policy updates that bring in such large public backlash. Even in absence of such policy updates, prior to the acquisition and prior to 2016 and 2021 updates, Data Now was a successful enterprise. It had no reasons whatsoever to bring in such policy updates, and it's clear that it has only been done to ensure that their interests and goals can align with its parent entity.
Okay, sure.
Your Lordships, regarding the economic unit claim, it's submitted that single economic doctrine states that wherein a parent company and its subsidiary can be treated as a single entity rather than as separate entities for competition law purposes, and this will be done usually when one entity exercises significant control or direction over another, preventing them from acting as an independent economic player. Lordships, in the European Union's case of AXO-CHEMI versus BV Commission, Lordships, it was held that there's a presumption that would always work in favor whenever it's a subsidiary and a parent company in contention, a presumption regarding the fact that the subsidiary company works under the influence of the parent entity. However, the court also stated that such a presumption is rebuttable, but in the present set of facts, Your Lordships, the respondents failed to understand how is that presumption rebutted. So we would work on the presumption that there was decisive influence of ConnectVerse over Data Now. Furthermore, Your Lordships, it is submitted that the threshold of enterprise liability herein has also been satisfied. Lordships, in Google LLC versus CCI, it was held that when a dominant position is abused by a subsidiary belonging to a larger economic unit, the fact of it belonging to this unit is sufficient for holding the parent liable. Lordships, also in the case of Hall versus EI DuPont, which was again a European Union case, Lordships, for the ease of the court, I would clearly state out the facts. Herein, the petitioners were a manufacturer of a dynamite blasting company, and across their testing practices, a lot of lives were lost. And since the caps of these blasting dynamites were destroyed in the process, it was difficult to hold which company was the one making them. So the petitioners went ahead with a common joint petition against this group of companies. And in this regard, the court held that if harm from the conduct flows out as a collective action for the entity in question, the causation for it will also be attached collectively. So, Your Lordships, in the present case, Data Now and ConnectVerse function as a single economic unit with integrated backend systems. Post-acquisition, policy shifts in 2016 and 2021 serving no independent function or benefit to data now. Your Lordship's data now is facilitating the funneling of data to connectors, and it is helping them to establish their monetization strategies and also create targeted profile advertising for consumers. Lordships, the causal nexus between data now and connectors has thus been established, and the fact that all these policy measures were done at the behest of connectors and for the benefit of connectors, it clearly satisfies the threshold of the single economic entity in this regard. Your Lordships, furthermore, in the case of Facebook versus CCI, as stated priorly by the Council, that it was asserted that Facebook as the parent entity of WhatsApp was the direct and immediate beneficiary of the data sharing policies put in place by WhatsApp. Therefore, it couldn't escape its liability under the law. Lordships, here also, as Facebook was interpleaded as a party to the suit, here in connectors should also be interpleaded by the similar logic. The fact that all the data which is being connected by data now is for the benefit and for the interests of its parent entity, and connectors is the direct beneficiary of this arrangement. Due to this fact, it is submitted that connectors should be impleaded in this investigation. If your Lordships are satisfied, the Council seeks the permission to begin submissions on the next issue.
Yes, please.
Much obliged, Your Lordship. Regarding issue 5, it is submitted that imposition of forced consent and non-granular data sharing amounts to an unfair trade practice and undermines consumer sovereignty. Your Lordships, firstly, regarding unfair trade practice, so the 2021 update here goes much further than just data sharing. It's clearly stated in the Moot prop that data now compelled users to share not just contact lists or usage data, but also metadata and payment details. This expansion clearly shows that data now is trying to leverage data-driven strategies into another market which is held primarily by connectors, which is its parent company. Your Lordships, a similar contention was raised in Vinod Kumar Gupta's case. This was also a part of the various series of petitions that was held against WhatsApp. Herein it was observed that data sharing terms of the privacy policy relate to the sharing of users' WhatsApp account information with Facebook to improve the online advertisement and product experiences available on users' Facebook page, and this conduct was found in contravention of section 42A. Your Lordships, privacy is right now here as a consideration for the free services that the petitioners are offering to the users, although there might not be any monetary considerations whatsoever. However, the trade that is happening right now is regarding the services that the petitioners provide, which in turn is supplemented by the privacy of the consumers. Lordship, by forcing users to mandatorily accept the terms and conditions without giving them any opt-out option, clearly establishes the fact that this is an unfair trade practice. And secondly, regarding the point of consumer sovereignty, Your Lordships, in the 2021 update, with its new policy, unlike the 2016 update, there was no opt-out option that was given to the consumers. Although the 2016 update did come with the policy of if you're not accepting the terms, you have the ability to opt out of our arrangement. However, it's after the 2021 update, the provision of an opt-out scheme was also taken back. Lordships, acceptance of the revised term was imposed as a precondition for continuing the access to their services. In the present case, wherein, as is already established, with 500 million users, where people are using data now not just to communicate, but to share images, to video call their partners, and also to make payments.
Where are you getting this factual information from, that there are video calling services on data now?
Lordships, it's not clearly provided for in the...
Why are you making that submission?
Lordships, it's a fact that whenever it's a OTT messaging space, such as data now, and as in the contemporary world is WhatsApp, it's not simply a messaging space. It does begin off with the end-to-end encrypted messaging platform only, but over time it develops various features.
That's a future issue that may or may not arise before this court.
Apologies for that, Your Lordships. If that is, I would retract that argument, I'm sorry.
Yes, please.
Lordships, so basically users were stripped of any consumer sovereignty that they had. Also, it was stated in the Digital Competition Expert Panel report, paragraph 1.121 to paragraph 1.123. It stated that if the consumers are not aware of the fact, why is the data being collected and for what purpose will it be used, this will be against the principles of an informed consent. Furthermore, Your Lordships, regarding section 6 of the DPDP Act, it states that a consent must be free, informed, specific and unconditional. Lordships, clearly the policy updates did not satisfy either of these.
Why is this being raised before this court?
Lordships, because conduct of data now is being assailed as unfair and arbitrary and is stripping the users of their consumer sovereignty. So all of these sections and provisions which have been mentioned, it is for the fact that in light of all of these scenarios, it is clearly distinguishable that data now's conduct was unfair and it was stripping the users of their autonomy and the sovereignty that they had. Lordships, regarding issue 7 and the final submission, that data privacy and informational asymmetry are non-price parameters of competition under fair competition law. Lordships, in the 2021 CCI report on the telecom sector, it recognized privacy as a non-price parameter. CCI's observation in the telecom report suggests that a lower privacy standard can result in exclusionary behavior and abuse of dominance by the enterprise that utilize consumer data. Your Lordships, data now is creating strong network effects for itself. If more users join the platform, they provide more data to it. And if massive data collection and processing takes place, that in itself is helping ConnectWorks to bolster its position and thus leveraging itself into another market. Lordships, data now's cross-platform integration allowed users from the messaging platform, for their data to be collected from within the messaging platform to be used for consumer profiling and advertising by ConnectWorks and other market. Lordships, in the case of WhatsApp versus CCI, specifically paragraph 30, the Commission clarified that the conduct of WhatsApp in forcing users to share their personal data with Facebook without a voluntary consent was prima facie unfair. This results in concentration of data, it creates comparative advantages and degrades non-price factors like privacy and equality. Lordships, it is thus submitted that since privacy is deemed a non-price parameter and when looked at in light of section 4 clause 2, lowering the standards of privacy will also be abusive of the dominant position that the entity holds. If your Lordships are satisfied, the Council seeks the permission to begin with the prayer.
Yes, please.
Your Lordships, in the light of the issues raised, arguments advanced and authorities cited, it is humbly submitted that the Honorable Court may be pleased to not pause or set aside the impugned investigation order on the ground that it's arbitrary, ultra-wise and procedurally invalid due to lack of quorum or improper invocation of the doctrine of necessity. Secondly, that the Honorable Court may declare that the FCAB acted within its jurisdiction by initiating a suo motu inquiry into issues that are already pending adjudication before constitutional courts and lie outside the scope of competition law. And finally, that the Honorable Court may be pleased to hold that ConnectWorks has rightly been impleaded in the present investigation in the absence of direct legal or operational nexus with the impugned 2021 update, and pass any other order it may deem fit in the interests of justice, equity, and good conscience. Your Lordships, it was a pleasure to argue before the bench. Thank you for your time and
Can you just
consideration.
explain the third prayer once more?
Lordships, the third point states, the Honorable Court may be pleased to hold ConnectWorks has rightly been impleaded in the investigation in the absence of direct legal or operational nexus with the 2021 update.
Just in one line, explain what you expect us to do in terms of prayer 3.
Uphold the impleadment of ConnectWorks within this investigation which the petitioners have been denying. Thank you, Lordships.
Both sides in the present case have presented their primary arguments. Team TC25, the petitioners, shall present their rebuttals for 5 minutes.
Much obliged, Your Lordship. Your Lordship, moving on to the issue 1, firstly, that my learned counsel has argued. Your Lordship, it is clearly proved by my co-counsel that under flag 9, para 79 of the alliance case, it is expressly mentioned administrative acts, Your Lordship. My learned opposite counsel has clearly misled the court by stating that the judgment does not mention it is judicial or administrative functions, Your Lordships. Your Lordships, flag 9, para 79. The highlighted portions, Your Lordships.
Yes, please. 79.
Para 79.
It's not sure. Sure, proceed.
Flags 9. Page number 27.
Please proceed.
Your Lordship, it is clearly mentioned that it is an clearly mentioned administrative act, whereas my learned opposite counsel has clearly misled the court by stating that the judgment does not mention it is a judicial or an administrative act, Your Lordships. Moving on to the case of CAT system that was cited by my learned co-counsel, it was in regards to the judicial member under the adjudicatory process, and the same cannot be applied in the administrative matters, Your Lordships. Your Lordship, moving on, the fact that my learned co-counsel has already stated that the proviso of section 22 is contained within the section 22 prove that the meeting within section 22 includes meeting under section 26(1) as it must be harmoniously read with the regulations, Your Lordships. Reading section 15 without in tandem to section 22 or 26(1) clearly demonstrates the fact that the provisions are left redundant without giving true meaning to the Fair Competition Act, Your Lordships. Moving on, Your Lordships, under issue 1, the learned co-counsel has failed to prove that how doctrine of necessity is applicable to prove why the principle of natural justice is required and why the Fair Competition Act failed to provide the audio alternate part of Fair Competition Act, and the doctrine of necessity was not proved at any point, Your Lordships. Moving on, Your Lordship, the learned co-counsel has also failed to prove that why such a narrow aspect of a market is being taken in the present case, Your Lordships. Even the learned co-counsel have failed to understand the true meaning of multi-homing here, Your Lordships, wherein they simply stated that the network effect determines and the market share determines that there is a dominance and abuse of dominance, Your Lordships. In the present case, the council has established a case of sponge iron manufacturing which clearly demonstrates that the mere market share cannot be held as a sole factor for determining dominance or abuse of dominance. Your Lordships, the strong network effect also is clearly for the benefit of the consumers in the present case, and the same was proved by the fast track association case by the council in its arguments. Your Lordship, moving on the fact that the learned co-counsel has stated that the consent of users are not being taken appropriately, whereas, Your Lordship, the council would like to rely on the acknowledged bounded rationality which the data now has taken. Your Lordship, also the factor that they have time and again emphasized on the beneficiary of Connectverse as a sole beneficiaries, but Your Lordship, the data now is using the infrastructure of Connectverse to provide better services to the consumer instead of the fact that Connectverse is merely using data now. It's a give and take process which is being going on, Your Lordship. Moving on to the fact that the council has mentioned that no consideration for users are being taken when they are collecting metadata or the transaction data, whereas, Your Lordship, para 5 of the proposition clearly states that they are not sharing personal data, and the end-to-end inscription of the data is being made sure to prove the fact that the consideration to users' data is duly given. Your Lordship, moving to the fact that the DPDP Act in itself recognizes legitimate purpose for the use of the data, and the same which the council will rely on. Your Lordship, moving on to the issue 6, the council have time and again presume that there is a managerial or administrative work that is there, because mere direct beneficiary does not prove managerial or administrative work. Your Lordship, it is merely for the better infrastructure that they have relied on. Your Lordship, the council has relied on the European Union presumption of managerial function, whereas, Your Lordship, in India, in the Indian law and the Indian precedent in the public insurance cartel case, it was clearly held that even though the government companies had 100% ownership, the de jure and de facto control cannot be proved from the mere shareholding of the companies in the present case, Your Lordship. Your Lordship, moving on to the factor that there are technical synergies that are there, but that does not demonstrate control, and that is merely a relative advantage as upheld by the Scott India case as well, Your Lordship. Moving on, Your Lordship, into the issue 7, that the metadata the arguments on the issue 7 were merely on a speculative basis that there might be some abuse of dominance that can come. Your Lordship, lastly stating the fact that the telecom, just last line, Your Lordship, the Telecom India has in itself pointed out that privacy and information asymmetry can be considered as anti-competitive only when there is a foreclosure in the market, which is not the case, and therefore the matter should be dealt before the Consumer Forum or as a Supreme Court that is there.
Noted your.
It was my honor arguing before this.
Team TC37, the respondents, shall present the rebuttals for 5 minutes.
Your Lordships, allow the Council to help rule the case in our favor. Your Lordships, I'd be dealing with the rebuttals firstly with the procedural law and then going ahead with the substantive law. Your Lordships, firstly, Section 17 has been used to say that the parties should have been given the right to notice, right to hearing. Your Lordships, Section 17 is, Regulation 17 is discretionary in nature. It does not give any binding right that is recognizable under the statute to the parties.
Can you just tell us which regulation you're talking of?
General Regulations
17.
Right, Your Lordships. It talks about preliminary conferences.
Council, I think you mean Regulation 18.
Right, as per General Regulations 2024, my bad. It means Regulation 18, but it provides for preliminary conferences which are discretionary in nature. These are not mandatory or provide statutory rights to the petitioners. Proceeding further, Your Lordships, the petitioners have argued that under the previous act, there was no quorum requirement, but under the Fair Competition Act, the quorum requirement was included in Section 22. If the intention of the legislature was to provide a quorum for Section 26(1) matters as well, they should have included the same in Section 26(1) matters as well. Proceeding further with the submissions with respect to ADIF versus CCI. Even if we accept as a matter of fact that for administrative purposes, quorum is required, Your Lordships, the councils also need to prove that Section 26(1) is an administrative provision. It deals with administrative powers of the CCI, which clearly has not been established. Moreover, Your Lordships, doctrine of necessity is something that we need not prove because Section 15 itself provides the Fair Competition Act, Fair Competition Authority of Bharat to proceed even with the lack of quorum. Moreover, they've used ADIF versus CCI to prove doctrine of necessity. Your Lordships, doctrine of necessity has not been engaged by ADIF versus CCI. Clearly, it's written in the judgment, and that cannot be a binding precedent for the same. Your Lordships, proceeding further. Your Lordships, civil consequences was largely dealt with by the counsel for the petitioners. They talk about the civil consequences of confidentiality. Your Lordships, Section 57 of the Fair Competition Act clearly provides confidentiality protection to the petitioners herein, and thereby civil consequences such as confidentiality do not arise. Moreover, Your Lordships, even with different rulings of Supreme Court of Bharat, even if it says that the particular policy update is an infringement on the fundamental rights, still the Fair Competition Authority of Bharat can proceed with the investigation because they have exercised their dominant position. Your Lordships, coming to the substantive part of the entire arguments. Your Lordships, jurisdiction lies at the core of the argument. Your Lordships, if you refer to the written submissions that have been made by the counsel for the respondents, we have accepted the jurisdiction of this court under protest, which essentially means that we contest the fact that jurisdiction with respect to substantive matters cannot be brought before this court under Section 226, which deals with writs, which deals with violation of fundamental rights per se. And Your Lordships, abuse of dominance, anti-competitive investigation into anti-competitive matters nowhere lie within the domain of investigation of abuse of fundamental rights. And therefore, the very core of their argument, that being the jurisdiction, has not been proved by the counsels for the petitioners. Proceeding further, Your Lordships, Section 42A1 is something that they had harped upon, is something that they tried to prove. However, Your Lordship, Section 42A1 deals with sale or purchase of goods and services. Here, there is no sale or purchase because there is no exchange of consideration. Your Lordships.
Are we suggesting the consideration only has to be monetary consideration?
Under 42A1, yes, Your Lordships. Proceeding further, Your Lordship, they have made self-contradictions in their arguments itself. First, they talk about data not being important, and then they say that in a digital economy, data is a very important factor. Your Lordships, let me clarify that we have taken a consistent stance with which is in consonance with the legislature. The Competition Law Committee, in its report of 2024, when it had suggested a draft DCB, had clearly specified that digital markets are different from normal markets, from regular markets, and in these markets, the tip-off can happen very quickly, and that is why there's necessity that we have a framework wherein the inquiry is conducted expeditiously, and therefore, your lordships, in digital markets, data being very important and tipping off can happen very quickly. Therefore, inquiry into these matters, even when there's a concurrent jurisdiction of the Supreme Court, is essential. Proceeding further, I'd just like to summarize on a...
Please sum it up.
Yeah, just a core principle of corporate law, your lordships. Subsidiary companies are bound by holding companies. The actions of subsidiary companies are directly regulated, monitored, and enforced by the holding company. And therefore, your lordships, here connectors impediment is very essential because the activities directly benefit firstly, and secondly, clearly seen that, as has been established by my learned co-counsel, is something that seems to be enforced by connectors on data now. And therefore, your lordships, applying the principles of...
Sorry, I know this is not the time. How are you getting the enforcement argument? Just because of dates, that this was 2021 when the promoter had control on data.
Also, your lordships, also the fact that when a company comes up with its policies, it's a natural assumption that they would come up with policies that would increase their market share, that would increase their user base, that would benefit them directly. However, policies were clearly data violation. There can be alleged data violation that would reduce the scope of its user base, that would reduce the market coverage. Therefore, your lordships, my line of reasoning does not help me understand.
It's an assumption that you're drawing, it's not there in the picture.
It's an assertion that we are making, your lordships. Lastly, your lordships, they talk about legitimate purpose of data as has been mentioned in the rebuttals. Your lordships, what is the legitimate purpose is something that they have not harped upon at all. Therefore, they have not justified the very fact why data extraction is happening. Therefore, your lordships, this being our case, we feel as an honor to argue before you. We rest our case, but definitely not our cause. Thank you, your lordships.
The honorable judges may note that the rounds now stand completed. Thank you all for all the teams and the audience. It was truly an honor to witness the final rounds. And with this, I announce the culmination of the final and ultimate round of first CCI-MNLUCS National Antitrust Moot Court Competition 2025. Thank you.
This time, we've taken it about. We have it. I'll just explain it to you.